Welcome to the Deep Dive, the place where we take complex source material and distill it, giving you a comprehensive understanding without, well, all the academic density. We try to cut through the jargon to get you informed fast. Today, we are undertaking a deep dive into South African commercial law, specifically a really foundational piece of legislation known as the Security by Means of Movable Property Act 57 of 1993. Now, this act might sound a bit dry, but trust me, it's much more than that. It's really the engine that allowed modern commercial lending to thrive, especially when we're talking about high-value business assets. Our mission today: to unpack this pivotal act, we want to explain its two central innovations. First, how it completely changed the game for using movable property as collateral, and second, how it protected those assets from a pretty notorious common law threat.
Yeah, and to really get why this act was such a big deal, you have to picture the situation before 1993. Imagine you run, say, a construction company. You need a massive, expensive crane, let's say R50 million worth. Now, a bank might be willing to finance it, but the traditional law, the common law pledge, required the bank to actually take physical possession of the crane to have proper security.
Which is completely impractical. Right?
Totally impractical.
Yeah.
If the bank takes your crane, how do you do any work? How do you generate the money to pay back the loan?
Sure.
It was this impossible catch-22 for lenders.
So they either had effective security or the borrower could actually run their business, not both.
Exactly. So this act, Sampiav, it essentially built the legal bridge needed to solve that problem.
Right. It allowed the law to catch up with how business actually works. The act stepped in, as you said, to regulate the legal consequences of registering a special type of security, this thing called a notarial bond over specified movable property. And crucially, it also aimed to exclude the operation of something called the landlord's tacit hypothec. We'll definitely get into that. Okay, let's unpack this then. Starting with probably the biggest legal shift the act introduced: the special notarial bond itself. That's in Section 1, isn't it?
That's right. Section 1, legal consequences of special notarial bond over movable property. It created this incredibly powerful tool for creditors, almost like a bit of legal magic, but with very strict rules.
Okay, so what are the requirements? It can't just be any bond.
No, definitely not. First, it has to be properly registered in the deeds registry. So it treats this movable asset almost with the seriousness of, say, a piece of land. Second, it must hypothecate. That's the legal term for granting a security interest over corporeal movable property.
Corporeal movable property, so physical stuff you can touch, like machines, vehicles.
Exactly. Tangible goods. Think machinery, specific equipment, maybe a fleet of vehicles, not just vague concepts.
And you mentioned strict rules. The description matters, right? The source says it has to be specified and described so it's readily recognizable. You can't just say, all my tools.
Absolutely critical. You can't bond all the factory equipment. It needs to be, XYZ milling machine, serial number 12345, that level of detail.
Why is that so important?
Well, remember, the debtor keeps the asset. So if things go wrong, say insolvency, or the debtor tries to sell it, the creditor needs absolute clarity on exactly which machine belongs to them under the bond. A liquidator or a sheriff needs to be able to walk in, look at the bond description, and point to the exact asset. No ambiguity.
Good. And then we get to the real innovation, the solution to that possession problem we talked about. Section 1.1.
Yeah.
It says something quite remarkable.
It does. It says notwithstanding the fact that the property has not been delivered to the mortgagee, so the lender doesn't physically have it, it shall be deemed to have been pledged to the mortgagee as effectually as if it had expressly been pledged and delivered to the mortgagee.
Deemed to have been pledged. That's the key phrase.
That's the legal fiction. It's fascinating, really. The law basically says, okay, we know you didn't physically hand it over, but because you registered this specific bond correctly, we're going to treat it as if you did.
So registration effectively replaces physical delivery for the purpose of creating the security.
Precisely. And that's how the security interest gets perfected.
Okay, let's pause there. Perfection. For listeners maybe not familiar with security law, what does that mean in practice? Why is perfecting a security interest so important?
Good question. Perfection is basically the point where your claim over that asset becomes sort of public and legally solid against everyone else, not just against the borrower you made the deal with. It means your claim ranks above unsecured creditors, and crucially, it will be recognized by an insolvency practitioner if the borrower unfortunately goes bankrupt. Without perfection, your security might just be a private promise, easily defeated.
So registration equals perfection under this act.
For these specific bonds, yes. And that unlocked so much commercial activity. Suddenly, Banks could confidently finance those big, expensive, movable assets. The cranes, the tractors, the specialized factory gear, because they knew their security was real, even while the borrower used the asset.
It makes sense. The business needs the asset to make money to repay the loan.
Exactly. Keeping possession is what makes the whole model work for most businesses.
And just quickly, the Act also provides for the end of the process, when the debt is paid off.
Yes, Section 1(2) covers that. Once the debt's cleared, the lender, the mortgagee, has a duty, free of charge, to provide the paperwork needed so the borrower, the mortgagor, can get the bond canceled in the deeds office. Cleans the slate.
Okay, so that established a powerful new tool going forward. But what about all the security arrangements that already existed before 1993? It must have been a bit messy.
It was. And the Act had to address that to bring uniformity. Section 1(3) dealt with older general notarial bonds, those registered before SAMPA started. The Act essentially gave these older bonds a boost, stating they would have the same preference in insolvency as a general bond under the Insolvency Act. It provided some much-needed clarity and standing for those prior agreements.
And this push for standardization, it seems like it got quite detailed. The sources mention the Act even looked backwards into ongoing insolvency cases.
Right. Here's where it gets really interesting, legally speaking. Sections 1, 4, and 5. These provisions were quite powerful. They allowed for the reopening of insolvency accounts that had already been confirmed by the master.
Wow, okay.
If the dividends hadn't actually been paid out yet. This was to ensure that creditors holding these types of bonds could get the preference the Act intended, even in processes that were already far along. And, importantly, they didn't need a special court order for that reopening.
That shows a real determination to make the new system stick immediately. And this drive for uniformity also meant cleaning up regional differences, I gather.
Absolutely. A key part of this was the specific repeal of the Notarial Bonds Natal Act 1932. Before SAMPA, Natal had its own specific rules for this kind of security.
Oh, okay.
SAMPA got rid of that. It created one single national standard for securing movable property this way. No more regional quirks.
And that standardization was locked in by changing the main insolvency law.
Correct. Section 4 of SAMPA amended the Insolvency Act 1936. It updated the definition of special mortgage in that act. It basically swapped out the reference to the old Natal Act and put in a reference to this new act, the Security by Means of Movable Property Act 1993.
So for a lender, that means their special notarial bond, created under SAMPA, is now formally recognized within the Insolvency Act itself as a top-tier security interest over those specified movable assets.
Precisely. Huge for lender confidence, especially in the bankruptcy scenario.
Okay, so that covers the creation of the security. But you mentioned another major goal, dealing with the landlord. Let's talk about Section 2, the exclusion of landlord's tacit hypothec. What exactly is this hypothec? It sounds quite archaic.
It is quite an old common law concept. The landlord's tacit hypothec. Tacit meaning silent or implied. It's basically the landlord's automatic, unseen right to seize movable goods found on their property if the tenant falls behind on rent.
Seize any movable goods, even if they belong to someone else like our lender with the crane.
Traditionally, yes, that was the terrifying part for lenders. The hypothec attached to goods present on the leased premises, regardless of who actually owned them or held security over them, like our crane financier. So imagine, you finance that R50 million crane, you register your perfect special notarial bond under Section 1, but then the construction company misses its office rent. Under the old rules, the landlord could potentially swoop in and seize your crane to cover the unpaid rent just because it was parked on their property.
That completely undermines the whole point of the special notarial bond.
Totally. It creates huge uncertainty. So Section 2 of SAMPA directly tackles this.
How does it stop the landlord?
It lays out two situations where movable property will not be subject to the landlord's hypothec. First, and most importantly for our discussion, if that property is hypothecated by a special notarial bond registered under Section 1(1, and it's still with the debtor or tenant.
So the registered bond now trumps the landlord's general claim.
Essentially, yes. The specific registered security takes precedence. The second situation is interesting because it shows how the Act evolved. Property is also exempt if it's part of an installment agreement under the National Credit Act 2005. That part was substituted in later, bringing consumer credit protection into alignment with this principle.
Okay, that makes sense. Protecting financed goods. But is the protection absolute? Is there any scenario where the landlord can still win against the bondholder?
Yes. Timing is crucial. Section 2 has a very important qualification. The landlord's hypothec is not excluded if the special notarial bond is registered after the landlord has already perfected their hypothec.
Perfected.
Yeah.
How does a landlord perfect this hypothec? It's not like they register it.
No, perfection for the landlord usually means taking legal action. Typically, getting a court order to attach the goods, or sometimes physically seizing them under that order. They have to take a positive step to assert their right.
So it's a race.
It's basically a race to perfection. If the lender registers the special notarial bond before the landlord gets that attachment order, the lender is protected. If the landlord attaches the goods before the bond is registered, the landlord's claim prevails over that specific asset for the rent owed.
Which really emphasizes why lenders need to register these bonds immediately.
Absolutely. Don't delay. Get it registered.
If we step back and look at the bigger picture here, Section 2 is really a fundamental shift in prioritizing creditors. It elevates the specific asset-backed lender, the one who financed the actual productive asset, above the general power of the landlord based purely on location. This was vital for encouraging finance for businesses operating out of leased premises.
Which is most businesses.
Very much. Okay, before we wrap up, just a couple of quick admin points. These aren't the most thrilling bits, but they show the act is still, a living piece of law.
Right. It commenced way back on 7 May 1993, but its administration was actually transferred just recently, June 2024, to the Minister of Justice and Constitutional Development. So it's actively managed.
And there's also a savings provision, Section 5. What does that do?
Yeah, that's basically making sure the act doesn't unintentionally mess up other specific legal rights. It confirms that SAMPA doesn't override certain existing rights held by the state or specific state-funded bodies. Importantly, it also preserves rights acquired under the Agricultural Credit Act, 1966. So it ensures the new system fits alongside older, specialized financing structures, particularly in agriculture, without causing conflict.
Okay, got it. So let's try and summarize the two massive transformations the Security by Means of Movable Property Act 1993 brought about.
Well, first, it made big, valuable movable assets truly bankable as collateral, thanks to that deemed pledge idea. Registration replaced the need for physical possession.
Allowing businesses to actually use the assets they were financing.
Exactly. And second, it protected those financed assets from being snatched away by a landlord just because rent was overdue through the exclusion of the tacit hypothecus.
It brought certainty, really. Certainty for lenders, clarity on who gets what in an insolvency.
Absolutely. That certainty is the bedrock that allowed a lot of commercial lending, especially for capital equipment, to flourish in South Africa. It clarified priorities and reduced risk significantly.
So for you, the learner, next time you encounter Santo 1993, remember it's the law that let businesses secure loans against their essential gear, cranes, machines, inventory without having to lock it away in the lender's warehouse. It let the wheels of commerce turn more smoothly.
It really did solve the problem for tangible, movable goods quite effectively. But, thinking about how the National Credit Act later had to amend Section 2 for installment agreements.
Yeah.
It does make you wonder.
Yeah.
Well, in today's economy, we deal more and more with intangible assets, software, data, intellectual property, and complex digital financial products. This act was designed for physical things. So the provocative question might be, what are the next big regulatory challenges in creating clear, reliable, enforceable security interests over these newer, less tangible forms of value? Are current laws keeping pace?